I'm Joy Mercy, and I'll be hosting today's webinar along with my co-host, Laika. It gives us immense pleasure to welcome you all to this enlightening session on navigating the digital frontiers and introduction to the Information Technology Act 2000, organized by Naksh Foundation under its flagship national initiative, Project CyberShield. In this rapidly evolving digital era, technology governs almost every aspect of our daily life, from online transactions to social media communications. The digital world offers both opportunities and challenges. To ensure safe and responsible digital conduct, it is essential to understand the laws that regulate cyberspace. And that's where today's session becomes especially significant. Before we begin, may we kindly seek your permission, sir, to record the session for educational and awareness purposes only?
Sure. Yes.
Thank you, sir. A few quick announcements before we start. Please keep your microphones muted to avoid background noise. You may share your questions in the chat box. They'll be taken up during the question and answer session. If possible, please keep your cameras on. Session more interactive. Now, before we dive into the session, let us see who we are. Naksh Foundation is a daily-based non-profit organization dedicated to promoting digital safety, cyber awareness, and responsible online behavior. Its national campaign, Project CyberShield, aims to empower students and the public with knowledge and tools needed to stay safe in the digital world. Through a series of awareness programs, webinars, and training sessions conducted across India, Project CyberShield continues to build a more informed and cyber-secure society. Now, it's my honor to introduce today's distinguished speaker, Mr. Gokul Prasad, LLM Assistant Professor in the Department of Cyberspace Law and Justice at the School of Excellence in Law in the Tamil Nadu Dr. Ambedkar Law University, Chennai. Sir has 3 years of professional experience as an advocate and 2 years of academic experience in teaching. With a strong passion for research, he has published 7 papers in peer-reviewed journals and presented several papers at national and international seminars and conferences. Mr. Gokul Prasad's deep expertise in cyber law and justice makes him not only an outstanding academician, but also an inspiring mentor for aspiring legal professionals. Today, Sir will be guiding us through the following key subtopics. Introduction to the Information Technology Act 2000, objectives of the ID Act, issues and scope of the Act, contraventions and offences under the ID Act. We are truly privileged to have you with us today, sir. Now, without any further delay, let's welcome our esteemed speaker, Mr. Gokul Prasad, sir. Over to you, sir.
Thank you, Joy Mercy.
Thank you, sir.
So, good evening to the participants. Thank you for assigning me as the host to this program. And I'm deeply grateful for the Shrutika, the student from Satyabama University, who has taken all the efforts. And also, I would like to equally thank Joy Mercy. I don't know much about Joy Mercy. You are also a student from Satyabama.
No, sir. I'm currently pursuing in Chennai School of Law, sir.
Good. Right. Fine. So thank you all for your wonderful introduction. And I will straight up go into the topic because the time given for me is just 1 hour. And the area which I wanted to explore is a little bit of a vast area. As you all know, cyber is an area where it is really interconnection between the jurisdictional problems and the technological interventions. To put it short, the Information Technology Act, which has been passed in 2000, which you all know, the Information Technology Act, which is been recommended by the UN Central Model Law on e-commerce. So to know about UN Central Model Law on e-commerce, actually, whether the slide has been presented to the participants? Joy Mercy?
No, sir.
The slide has
Sir,
been
do you
presented.
want to present the slide, sir?
Yeah. Shall I present or you are presenting?
Okay, sir, I'll try to present it, sir. Sir, but the slide is not in PPT format, sir, so it will not be visible fully. Is that okay?
Yeah, I will share.
Okay, sir.
Is it visible now?
Yes,
Yes,
sir.
sir.
Yeah. But I couldn't able to change the slide. Yeah, I will try to do. Okay, we will straight up go into the topic. Yes, we don't have much time, right?
Do you want me to share the screen, sir?
Yeah, if it is presented, then it will be fine to the
Okay,
participants
sir,
to
then I'll
understand.
press.
Because otherwise it's like a conversation which can be made.
Okay, sir, I'll do
Yeah.
that.
Okay. Anyway, so you all know about the Information Technology Act, which has been passed in 2000, which is a precursor or which has been taken from the UN Central Model Law. India is the 12th country to adopt this Information Technology Act. And it has been amended in 2008, and also we have several rules which has been framed and amended in the time. You also know about the 2021 Information Technology rules, where the intermediaries have been imposed the guidelines to be followed, and that is the reason why our social media platforms have been following guidelines strictly. And also, if any information which is against the state or maybe against the community guidelines which has been prescribed by the 2021 rules, if it is violated, then the content will be removed immediately. So these are all general areas where we are going to touch upon to know about first, because the aspect is we will cover one by one as to which are all the topics which we have in this information technology. So Information Technology Act was enacted in 17th May 2000, and India is the 12th nation, as I already told. And this act is based on the UN Central Model Law on e-commerce. So the UN Central Model Law has been adopted by the United Nations to provide for recognition for electronic records. So you know all about the electronic record which we have been using since 2000, and before that the electronic record was not that much popular and prominent, isn't it? So this electronic record needs to be legally recognized at that point of time. That was the only intention of the legislators. And also the cyber crimes have been on the rise at that particular point. So that is the only reason why UN Central Model Law has been given by the United Nations for the countries to adopt. And as you know, 12th country is India. Before that, several countries adopted. So this IT Act, which is a direct skeleton from the UN Central Model Law, consists of 94 sections and 13 chapters. If you are a student of law, it will be very useful for you. Otherwise, if you are from forensic department or maybe a forensic student, it will be useful for you for your study purpose. And I'm just explaining about what first we need to address that, right? So on the information. So first thing we need to understand what is the information under this Information Technology Act. So what do you mean by information under this Information Technology Act? So as explained by the IT Act, includes data. In information includes data, message, text, images, sound, voice, codes, computer programs, software and database, or microfilm or computer generated microfiche. You know this microfilm and microfiche has been used in the older days. Nowadays we couldn't able to see. Even the people who are born after 2000 will not know about this and all. You know the negative prints which we had in the past. Anybody know about the negative prints which the reel will be taken and it will be negative will be converted into a photograph. Anybody know about that? Can you please put a message in the chat box? Yes or no? Yeah. Can you move to the next slide? Joy Mercy. Can you please move? Oh, so no, sir. Okay, that was quite. Yeah, I'm not surprised about the answer because I can able to see that most of you are born above 2000, it seems. So you might not be knowing the facts. Okay. Anyway, but even after. Anyway, even if you. Yeah. Okay. No. Fine. So even if you are born above 2000, this IT Act holds relevance still now. Why? Because cyber crimes and the legal recognition of electronic records is still in use, and it is being used, and it will be used. So it is the past, present, and future. So cyber is the future. That is the right word to pronounce. Cyber is the future. In the past we didn't use cyber. Why? In the past, we didn't use the cyber. Why? Because information is the only thing which we had knowledge about at that particular time. Cyber is an ecosystem. You need to understand that. Cyber is an ecosystem where in the recent times you know about information, Internet of Things, you know about artificial intelligence, you know about this social media. These are all recent developments after 2011, after the induction of the evolution of smartphones. Before the smartphone era, there were no, which means not no problem, but the problem was very less when compared to the current era, where the mobile phones penetration and the digital access was much more faster and easier. The cheap access to cheap rates of internet and the availability and the digital penetration is much more. You can see now where I am just talking to you, right, sitting from my home and sharing information. Yeah, actually there was information and information technology. But there was a cyber space, and the ecosystem was not developed at that time when compared to this era. So the ecosystem was not developed. It was at the beginning stage, where there and at that 2000s the cyberspace was there, but not to the extent where we are seeing now. And also we could see in the future. So this cyberspace had a more expansionary definition now rather than 2000s. So that is what making cyber the most dynamic field to make a legislation about. Even you can see the Information Technology Act is becoming redundant when it comes to artificial intelligence. We don't have any legislation which addresses the issues of artificial intelligence. In case of an information which is given by artificial intelligence as an infringement of copyright, who will be held liable for that? And all this, the punishment and penalties for that matter, we are still going to the old Copyright Act, where the general definitions and penalties were given for violation and infringement of copyright. So this ecosystem has a large definition, and also it is very deep, so that it becomes difficult for the legislation to cope up with. Technology is always much faster, and it is like we are running behind technology to cope up with the pace of the technology, and we are bridging the gap. So that is what we are trying to do. We, in the sense, the legislators, maybe also the governments, which I am saying about. So the governments were running behind the technology always. This thing is happening right from the past. It's not Could you able to hear me?
Yes, sir. Now you are audible, sir.
Yeah, that's a technical glitch actually. So the IT Act, when it comes, so I'm just explaining what are all the aspects which we have in the cyberspace, and within 1 hour we couldn't able to reach all of the aspects, but I could try to do much justice to all of the listeners by just giving you the insights of what are all the things which we can know about the cyberspace and law. So if you are an advocate or maybe a student of law who could practice in that particular area, what are all the areas you can able to know, I will be able to explain in this 1 hour or 45 minutes which I have. So the objective of IT Act is the legal recognition to electronic records. That is one thing which has been directly taken from UN Civil Model Law. And the other thing is to regulate or to prohibit the cyber crimes which were on the rise at that particular time in 2000s and even now. You can always see that the cyber crimes are happening now and then, and you can able to find, if you are an avid reader of newspaper, you can able to find a lot of issues which are happening around the cyber crimes. Recently the ransomware attack which has happened on the AIMS, right? So what is a ransomware? Is that a malware will be injected into a computer where the computer will be locked and they will be demanding ransoms. Ransom in the sense for money. And after that they will provide the password, and after all the things will happen. This is the modus operandi of ransomware. And likewise, several crimes are happening. Like phishing is there, cyber smishing and wishing. All these things are happening. There is also things like deepfake. Deepfake is a very recent issue which is on the rise. And this deepfake one notification has been recently released by the MITY, Ministry of Electronics and Information Technology. They have been inviting suggestions from the stakeholders and public relating to this deepfake. The synthetically generated information. The deepfake is also called as synthetically generated information. And regarding this, a law need to be framed, and the public consultation has been asked from the particular stakeholders and public as in general. So deepfake is a big area where we need to address, and the legislation is lacking on that particular area. And not only deepfake, we have credit card frauds. That's credit card schemings are happening on a large scale, and we have the UPI frauds. We have even the cyberbullying, the online gaming. Right from you can take several issues in the cyberspace where most of them are unregulated. The Online Gaming Act has been recently passed in 2025, which also completely bans the online money games. The Rummy and Poker and all the games which the advertisements and everything has been banned now. So completely it has been banned, online money games. And the online money games has been led to several suicides in the country. That also the age which is ranging between 14 to 25, the people who are within the age were actually they were committing suicides, and several socio-economic problems were arising at the particular aspect in the particular field. So several type of crimes are happening, and to address these crimes at that point of time there were no such crimes, but they wanted to address certain crimes like phishing, bullying, or not bullying but phishing and other types of crime, virus and Trojan attacks were prevalent at the time. So for that reason they had created, or they have enacted this particular legislation called as Information Technology Act. So there is two things for which this legislation has been enacted. One is to recognize the electronic records. So Anuj has raised the hands. Any doubt? Can you able to ask in the chat box? I can able to reply.
So can you ask a question?
Anything?
Yes, sir. I will write it in chat box.
Yeah. Okay. So the two things for which this legislation has been enacted. One is to legally recognize the electronic records and to prevent the cyber crimes. So this act consists of 94 sections, and this act has also changed or amended the other legislations like Indian Evidence Act. Indian Evidence Act is the act which is providing for how to submit the evidence in the court of law, where how digital evidence can be submitted in the court of law or admitted, and what are all the procedures which are followed, which need to be followed when you need to submit the digital evidence in the court of law. So all these things need which has been changed after the enactment of the legislation called as Information Technology Act. The Indian Evidence Act was changed, the Bankers Book of Evidence Act 1891 changed, and the Reserve Bank of India Act relating to electronic checks and electronic transactions have been changed. So all these things have been changed. Dream Loan is a sponsor of Indian cricket team. Yeah, Dream Loan is a sponsor of Indian cricket team, but it doesn't mean that Dream Loan can be promoted and it can be circulated among the young people to play without any concurrence with the parents or the consent with the parents, right? So the age factor needs to be considered, right? So that is what the fantasy games need. It actually, what's your question really? So it is banned in all the states now because it is a central legislation, Anuj. So the online gaming act can able to go in the Indian Gazette and you can see.
Sorry to interrupt, but sir, in every phone we can find any online game, sir, because every person now they are traveling on bike. Persons are like for stress relieving, they are playing the online games in which
Yeah,
money
yeah,
is involved.
yeah. I can understand the question.
So how can we
Actually,
ban, sir? Like
yeah, I will address. Yeah, anything? Yeah, you
yes, sir, yes,
complete.
sir. Yes, sir, you complete, sir. I asked, sir. Thank you, sir.
Yeah, actually, the question is a brilliant question which needs to be heard by everyone. Actually, online games in the act, in the particular act, they have been categorized the games into three categories. One is online money games, another is online social games, and another is fantasy games. And they also categorized another type of game which is not a game but esports. So it is a sports which has been recognized by Sports Authority. And it needs to be actually this esports is a different event where it will be conducted like an Olympics. So that thing is different. So whatever you have asked, coming to that point. So for recreation purpose, if you want to play, they are categorized one particular sector called as social games. In the social game sector, an online gaming authority has been established in this particular sector, right? So this online gaming authority will regulate this area, and if any gamer develops a particular game, and if they want to be circulated in the Play Store or maybe in the market, then they need to get an approval from the online gaming authority. This online gaming authority will differentiate whether it is a money game or whether it is a social game, and after that they will give the permission to be circulated in the market. If it is a money game, if they recognize it as a money game, they will definitely ban it. Or if it is a social game for entertainment and educational purposes, they can able to regulate and they can able to allow that. So the license will be given to that particular developer. So am I answering the question?
Thank you, sir. Thank you.
Yeah. Okay. So that the question which he asked is whether online games were banned in any state, particular state, or it is a blanket ban on each and every state, which means India, pan-India legislation. So the pan-India, it is a pan-India legislation, and it has been banned all over the country. Online money games has been banned all over the country, right? Hope I answered the question, right? So it penalizes computer-related crimes. So first aspect, electronic records. To recognize the electronic record, why we need to recognize the electronic record? Because e-commerce is an area where we deal in invoices, we deal in messages where contracts will be online. You know about e-contracts, right? The types of e-contracts. What are the types of e-contracts? We have shrink wrap contracts. We have click wrap contracts and bounce wrap contracts. So by the touch of a button, you agree to particular terms and conditions. Each and every time when you enter into an application, you touch the I agree button. So whenever you touch the I agree button, you're entering into a contract. But much of you don't know about the legal implications of what you are doing, because our only intention is to get into the app and use the features of that particular application. But the intention behind that is, if anything goes wrong, they will have all the clauses which are inserted into the contracts where they will be at advantage most of the times. But nowadays, the government is intervening and they are most likely suggesting not to go for unfair contracts. So there are e-contracts. You know about Amazon. Whenever you go into that particular application, they will ask for your credentials, and after that you need to agree for the thing. Then only they will let you into the app, that particular application. Not only Amazon, you have each and every e-commerce applications, and they will have the jurisdictional clause which has been embedded into that particular contracts, and they will have the disclaimer clauses where if any seller has been violating the things, or maybe buyer violating the norms, all these things have been given under this contracts, right? So due to the evolution of the smart contracts, they need some recognition, because they means the judiciary needs the recognition to take these contracts into consideration. Because just like that, for example, if you take physical evidence, physical evidence need to be submitted in the court of law. So, for example, a contract which has been made between a party, two parties, right? So, for example, a sale agreement. A sale agreement has been executed between two parties. How can they prove? They can just show the agreement which they have been signing, and with the witness, you have two witnesses who have been signed to that agreement. You have the government stamp duty which you have paid, and all these things were the evidence that you have executed the contract, right? Sale agreement. But what else? What if you want to prove a digital contract, a smart contract, which you have made online? The only thing which you need is to provide legal recognition to the particular e-contracts. That is done through this IT Act. You understood? So that is done through the IT Act. And after that, when you go for this legal recognition of this contracts, how can you legally recognize? For example, I will say one thing where if for example, if anyone is going for a bank statement, if going to see the bank statement, if someone is going for this online banking application, and you want to download the bank statement, the bank statement will be sent to you through email, right? And in the mail, if you open the mail and touch the particular the PDF or whatever in any format which they have sent, they will ask for passwords. Why the password has been set? And into the particular document, one digital signature will be placed by the bank manager or maybe a higher authority who is having an officially responsible position in the particular bank. So why is that happening? That is the legal recognition which is given to the electronic record, right? So that is the legal recognition given to the electronic record. If you see that particular signature after entering the password, for example, the password will be, can we see contracts as sort of, standard form contracts is one type of contract, where it is like, for example, standard form contracts, you can say this railway forms, it is a physical standard form contract. And in online, if they fill all these things and if you want to just sign or maybe touch the button, I agree, that is a standard form contract. So most of the online contracts will be standard form contracts. Don't need to worry about that. So most of the online contracts are standard form contracts. So this is the only thing. And after that, when it comes to the issue which we are discussing, actually, the contracts which need to be legally recognized. So for this, the digital signature need to be affixed, isn't it? So the digital signature will be affixed through a process called authentication of electronic records. That is the important area which is discussed under the IT Act. The authentication of electronic records. Can you move to the next slide? Okay. Secure transactions to enable parties to enter into contracts. So these are the first. This is the first issue which is covered by enacting this legislation. If you see the Information Technology Act Section 3, it provides for authentication of electronic records. What is authentication? Authentication, if you see the general definition of authentication, it is like trusting that particular record. So authenticity. Authenticity means verifiability, which means the particular record is verified. So that is called as authentication. A honest one. We can say in a general parlance, it is a honest one and can be trusted. So that is what authentication means. And to take this into idea concern, we can see that there are two procedures which have been mentioned under this Section 3 of IT Act. So what are the two procedures which are mentioned? One is asymmetric crypto system. So asymmetric cryptography is one technique which has been mentioned, and the second one is hash function. So in order to understand the asymmetric crypto system, we need to know what is a cryptography first. So what is a cryptography? A cryptography is a data hiding technique. right? A data hiding technique. For example, WhatsApp uses end-to-end encrypted systems. If anyone knows, you would have watched the chat box below that. One word will be called end-to-end encrypted will be there. Have you ever watched that? End-to-end encrypted. So that is a form of authentication. So that is a form of authentication where if you send one message, it will be transferred to the receiver, and in the process, if it flows through the internet, in between there is a chance that someone will able to peep into the message and they can able to see. To prevent this from happening, we follow a procedure called as authentication of electronic records. To prevent this process from happening, which means if anyone wants to see or if anyone wants to tamper the electronic record, what is meant by tampering? The tampering means it's like changing the information. It's verification that message is only accessed by us with use. Can you able to ask the question directly? I couldn't understand. Can you please explain into and encrypted? Okay, so I will explain. Yes, that's what I am coming to say. Actually, the asymmetric crypto system will have two keys, right? So there is a public key and a private key, right? You know about that, right? There will be a public key and a private key. So in the previous days, we used symmetric cryptography. Before this asymmetric crypto system has been evolved, we used symmetric cryptography where only one key will be used at both ends. Like sender send and receiver send, both ends will be using only one key. But in this case, actually in the asymmetric cryptography case, both the ends will have different keys. One private key and a public key will be there for both the ends. And these keys will be generated at once. These keys will be generated at once, and these keys will be given to the particular person who is a digital signature subscriber. A subscriber. For example, who is a subscriber who wants to give the document by signing it digitally. So who is called a subscriber. So this is the person who is a subscriber, and a person who receives is a receiver, and he will have his own public key, right? So he will have this, which means the communicator, which means the person who is giving the message will have a private key, and the person who is receiving the message will have a public key. And if with this private key, what the sender will be communicating is that actually when he uses the system, these are all back-end process, no? All these things are back-end process, and there is nothing to be done by the person who is sending the message. Because if you take the example of WhatsApp, whether you are doing any encryption process in that, you are just sending a message, right? You are just sending a message by click of a button, right? For example, if Google is sending message to Joy, I will just say hi, right? I'm just sending a message like hi, how are you? So this is the message I'm sending to Joy, right? I don't have anything to do with the encryption process because I'm using the platform called WhatsApp. The WhatsApp will have an encryption process, an asymmetric crypto system will be followed, and maybe the digital technology will be included in the particular process and affixed to that particular application, and the private key and public key will be applied in the backend process, right? So it is the process of developer where a developer will develop, when they develop the WhatsApp application, they will provide a code where the private key, the hash function, and the public key will be used accordingly when sender sends the message and the receiver receives the message, right? So in between the transaction, if the sender sends the message, in between the transaction, the first thing, the private key will be applied automatically. It's a backend process, and after that, it will be converted to a alphanumeric code, because hi, how are you, which I typed to Joy Mercy, will be converted to alphanumerics, which means it cannot be understood by naked eye, which means our human understanding. It is a machine language, right? So it will be converted to like dollar or zero or one or prime numbers or whatever. So the numbers and the symbols will be changed. Like hi, how are you will not be in the same form of hi, how are you. When you enter into the internet forum, a hacker or any kind of person who is unauthorized to access the information who comes into the system and sees the particular message, he couldn't be able to see the original hi, how are you. He just able to see the alphanumeric words. So that is the speciality of encryption. So that is why we call it end-to-end encrypted, which means nobody other than Google and Joy can be able to see the particular message in the transit. But you can ask me that whether we can see in the mobile phone of Joy. Yes, you can surely see, but you cannot able to see with other device in the transit, right? Maybe WhatsApp may be connected to some other device. Joy's WhatsApp may be connected to some other device. In that particular case, you can easily see that. But in the process where without the consent of Joy, any other person wants to see the message, they cannot able to see. So that is the main significance of encryption. And when it comes to decryption, as I said, a public key will be given to Joy, which means it will not be given to directly from Google to Joy. It is like the system will be generated in such a way that the public key will be applied after I send the message. You can see the two tick boxes, or maybe if an acknowledgement things. That are all the additional features which has been employed by WhatsApp in order to gain users. So that is different. But in order to get the thing which is protected, the backend process, public key will be applied, and the public key, for example, in some cases, in email, if you receive a document, the public key is given to the particular receiver itself. For example, in SBI, if you want banking systems, right? If you want to download, if you want to download the statement of your transactions, one document will be given. For past 6 months, if you select, they will give you a PDF document. If you want to open the document, you need to produce the password, right? The password will be given in such a way that it is like date of birth, month and year. So that is a public key. That public key will be visible only to you. Sometimes public key will be directly sent to you. Sometimes it will be embedded into the system. So both things are there, right? And then comes the multi-factor authentication, where you will be using this encryption system, and also PIN or other type of electronic signatures also will be used. So this is a multi-factor authentication. Mostly nowadays we are using multi-factor authentication. So why? Because this gives additional protection to the document. So it gives additional protection to the document. API key. So API key, it is a public key or private key. Mostly API key, actually it won't be a public key or a private key. It is different actually. API is an interface, right? So it is not a key. So API is not a key actually. So a public key or a private key alone will be used in the asymmetric closure system, right? Okay, so I couldn't be able to get the question. Right? API key, I will explain it later. So first thing, after that, we have multi-factor authentication. So the asymmetric cryptography will be used to protect the document and digitally sign the document. And in order to verify that, a public key will be used, and the public key will be applied to the particular function. And if the message is received by Joy, then Joy can confirm that this message is protected. And if the protection is called as verification. So two things is done in this process. One is authentication and another is verification. How you verify? You verify only through the process called as by applying the public key. So WhatsApp will not show the public key to you, but maybe SBI is showing the public key to you. So that is the process where you are verifying the document that is seen by no one, and also the document is not tampered in between the process. Because sometimes you may see documents in the older days when the regulation was not there. Sometimes hackers will hack into the particular system, and they can able to tamper the document. They tamper the original document. So that things, even if they tamper the particular document, you can able to see the hash function will be changing. So what is a hash function now? So that is different from asymmetric, which means the public key and private key function. So two things have been mentioned under section 3. One is asymmetric cryptography and another is hash function. Both are authentication techniques, right? So both will be applied in a single process. So first thing, public key. After that, hash function will be applied to the particular public key. Okay. So the hash function will be applied to the particular private key. The first thing, receiver will apply, sender will apply the private key, and a hash function will be applied. And after that, this hash function will be transferred, which means the document will be transferred along with the encrypted message to the receiver, and receiver will apply both the hash function and the public key to open the document. And after that, when the hash function matches, the hash function which is received by the sender and the hash function which is received by the receiver, both of them matches, then it is considered to be a valid one, and that is verified. So this is a highly back-end process, and this won't be clear to you when you just know things which are not in the coding perspective. So these are all coders' perspectives. So you just know these techniques have been introduced by Information Technology Act and legally recognized. Okay, in order to legally recognize electronic record, where we will use this electronic record technique, if it is asymmetric, the asymmetric cryptosystem is used in the particular electronic record, courts will consider to admit the particular evidence. Otherwise, if you are not having digitally verified signature, then court will not consider the particular thing as a valid one. And even if they try to admit the particular evidence which you are producing, you need to provide a certificate for the same, a certificate of admissibility. In that particular aspect, a certificate of admissibility, if not able to be achieved or maybe submitted, the court will reject the evidence. So this is the area where we are facing the difficulty, where most of them couldn't able to acquire the certificate of admissibility at a much faster pace, which means shortly couldn't be able to achieve to get the document, which means the certificate of admissibility. Why? Because the admissibility is a separate area where it can be dealt in a different class, because actually the time is very limited, it's just in 10 minutes more. So I will just explain what are all the issues which are covered under the IT Act, right? So the admissibility is a different part where courts will be engaging in that. So courts procedures and how the evidence will be submitted in court, and how the forensic department will submit their own evidence, and the chain of custody which is being followed by the forensic department, any investigating officers. All these things will be, if I get a chance to deliver a lecture on admissibility, I will definitely tell you. So regarding these issues which are covered in this particular act, the contraventions have been defined. Contraventions such as hacking and spreading virus, and offenses. So there is a difference between contravention and offense. So what is a contravention? A contravention in such a case where if you study law, you would have understood that what is the difference between an offense and an offense. If you can able to define the offense, any law which is codified and penalizes certain aspects of crime which is generally regarded by the society will be called as offense. So anything which is codified, any particular act which is codified is called an offense, and which is regarded as crime by the society. And if it wants to be codified, then legislation will make an act which is IPC is a codified act which provides for offenses, and anything which is outside the Indian Penal Code will be a crime, right? So it will be a crime, and anything which is provided as a code from numbers in the form of numbers from 1 to 511 sections we have in IPC, which are all codified offenses, right? So this is the difference between a crime and an offense. And what is the difference between an offense and a contravention is that a contravention, so in order to understand what is a crime, or what is an offense, you need to understand what is mens rea and actus reus. So that is clearly a legal terminology where mens rea, an evil intention. Always when a crime or an offense need to happen, two things need to be there in the mind of the perpetrator. One is mens rea, which is evil intention, and another thing, an act need to be committed. So under the guise of the evil intention, he need to commit an act. If both of them is there, then only it is considered to be an offense. Any one of them is missing, like if when mens rea is there, actus reus is not there, it is not an offense. Or if actus is there, mens rea is not there, this is also considered not to be an offense. So both should be there, and then only it considered to be an offense. If there is no evil intention, but only for a funny purpose, if someone wants to enter into a computer of some other person, like if they want to do hacking for a fun purpose without any evil intention, for fun purpose, right? So that is called as a contravention. If they want to spread virus without any malicious intention or through negligence, if they do something through negligence, if they are not an ethical hacker, if they not have the certificate of ethical hacking and do hacking for some purpose which are not evil intended, which are not an offense, then that is called as contravention. So these contraventions have also been provided, like spreading virus for some for fun. Like some persons will have the mentality, an ill mentality, which always will be there, right? So just to spread virus and just to spread some other kind of malware and trojans into other systems, like spreading virus to all the humans. Like same thing digitally it happens. So some persons will have that ill mentality, and this is called as a contravention. And negligence is also a part of contravention, right? So for that, compensation will be given to the person who is affected, and the victim will be accordingly compensated for the damages which has been happened to them, right? And for offense, generally punishment only will be given. So that is the difference. Contravention, for contravention, no punishment like imprisonment will be given. The compensation will be given for the damage caused. But for offense, along with the compensation or fine which has been imposed, you need to also suffer the imprisonment of maybe the terms according to the offense. Like for example, offenses have been mentioned from sections 65 to 73 of 74 of ID Act, where you start from tampering the computer source code. There is an offense for tampering computer source code. For example, if Microsoft has coded certain application and or maybe a software, and if you want to change the code of the particular software by illicit means, and if you want to sell it in the market, right? So that is an offense under section 65. If you want to change the Microsoft the codes which have been made and the interface which is used by the Microsoft, then you cannot able to do that. And you have the open source codes. Even if you do that, that is also an offense. With open source, you can develop your own code, which should be innovative and novel. But you should not copy some other's work, and you can able to produce it. So that is tampering of source code. And also for So it's it's not like it is a contravention and it is a civil wrong. Civil wrong means a tort, maybe tortious act, which is less severe. It is not on par with the offense. So it is less severe. Generally, you can, if you know about the torts, right, civil wrong. So that is considered to be a civil wrong contravention. The same as that. So that is what it is. And when you come to these other offenses which have been mentioned, 66A, you know about this computer-related offenses, right? Spreading hatred among the communities, or maybe spreading false information or misinformation against the government. So all these things have been mentioned under 66A, where social media, an important case also have been mentioned by the Supreme Court in 2015. If you see that on holdings is there, right? Raya Singhal versus Union of India case, where 66A section has been struck down. So this section says that if anyone is posting some information online, which is against the community or maybe the government or maybe any persons, right? So that content also can be removed and the person can also be arrested immediately. So that is what this thing is. But the opposite side which is arguing is that actually how can you arrest a person for giving a fair criticism against the government? So all the parties are doing fair criticism against the government, and if fair criticism has been curbed, then democracy will be at stake, right? So the scope of freedom of speech, yes, brought on the scope of freedom of speech, very good. So democracy will be at stake, and it brought on the scope of freedom of speech and expression. So that is simple as that. And privacy and confidentiality by providing digital signature and electronic signature definitions have been made in this IT Act, and consent for consumers to use their personal information made mandatory. So in this consent is very important, right? So the data privacy and other things. So only one section provided for data protection in this particular Act, 43A, where if a person, an intermediary who is containing your data, if they fail to protect the data, or a corporate or any firm, if they fail to protect the data, the compensation is provided for you, and the compensation is 1 crore. Initially, it was not 1 crore; it was 50,000. Before that, after some days, after some years, it has been changed to 1 crore. And now it is completely changed the regime. Actually, after the enactment of Digital Personal Data Protection Act 2023, you know about that, right? The rules also has been framed in 2025, according to which compensation procedures under the Digital Data Protection Act has been completely changed. So all these things have been changed, and the penalties was much more higher than what is there in the IT Act, because the penalty for the failure to protect the data is 150 crores for the big tech companies. Like if Facebook is failing to protect your data, or maybe if Meta is Facebook, and also the other type, Twitter and other areas. So this social medias, if they fail to protect your data, then 150 crores penalty will be imposed upon them. And if they fail to protect the children's data, like if a child pornographic content is spread on the particular social media, then 250 crore penalty has been imposed upon this particular act. And the person who is violating will be imposed. So mostly 150 and 250 crores itself says that it is only for big tech companies and social media intermediaries, where their liability needs to be stringent. So that is the only thing. And damage or misuse of personal data attracts penalty. That's what I explained. The next slide. Can you able to move next slide? Yeah, scope of the act. So the scope of the act, this is nothing but a limitation to this act. 1 clause 4 act says that the section 1 clause 4 of the particular act says that it is not applicable to certain documents, which I already explained about the sale agreement, right? So sale agreement in physical form, actually, what is the penalty, sir? How many crores? It is 150 crore for the body corporates, 150 crores. You can also verify in the Digital Personal Data Protection Act. So it is 150 crores. So it is. I can understand why you ask this question. So little bit higher when it comes to individual consent. This provision is not for individuals, right? This is for intermediaries who consist or who transfers with, who plays with this significant data, right? For individuals, there is no provision, and it is always relying back to the IT Act. So IT Act 43A for individuals. So it will be up to 1 crore, but not exceeding that. Actually, individual won't breach your data, and why you need to give individual your trust. So mostly it won't happen. Your data will not be breached, and that is called as hacking. So if they want to breach your data, it is with your permission only. They cannot be able to do without your permission, right? You are trusting the social media platforms and giving your personal information. You are trusting your bank and you are giving your information. You are trusting each and every medical sector and you are giving your personal information. This particular section from the DPDP Act is for them, the intermediaries who want to protect your data, who are all called as fiduciaries. You understood? So are you clear with that explanation? Okay. So, Negotiable Instrument Act has been defined under 13, and for this Negotiable Instrument Act, it won't be applicable. You know about the negotiable instrument. Any instrument which can be transferred and it can be converted into real money by any other individuals. For example, a check. A check is a negotiable instrument. A bill of exchange is a negotiable instrument. Or another promissory note is a negotiable instrument. So these negotiable instruments, this act will not apply, right? And a power of attorney, someone will give you the power to handle that particular property, who may be in a foreign country, and they will give or impose the power upon you to handle that particular property. So that is called as power of attorney. And for the power of attorney, it won't apply. And the trust, which is defined under Trust Act, right? So what is a trust? A trust is a collective body where a group of individuals will come together and they will maintain a particular, maybe any religious place or maybe anything related to that. And this trust, anything which is a trust covered thing under Section 3 of Trust Act will not be applicable to this idea. And will, the testamentary succession. If will is need to be there, then will is not applicable. So if you and also the fifth one, contract of sale and conveyance of immovable property will not be applicable. So if you see all these things, these are all not applicable to this IT Act. So the IT Act will not apply. All the electronic records which are converted. For example, if you want to do a sale deed electronically, then it is not applicable. So you cannot able to affix the digital signature and you can show to the registrar of sale, the registration department that so it is digitally verified and my land is registered. It's not the case. You cannot do that. So land will be registered physically with the witness as the same as the olden days, right? And the government is trying to digitally do all these things, everything digitization of land records and other things. But in India, all these practical situations, how land records have been maintained, and then they're quite difficult thing to do. Can you please able to change the slide, Joy. Yeah, Amendments to Evidence Act. Change the slide. I explained this. So now Evidence Act also has been completely changed actually. So you know about Bharatiya Sakshya Adhiniyam. So Bharatiya Sakshya Adhiniyam has been replacing the Evidence Act, and section 63 of this Evidence Act provides for Bharatiya Sakshya Adhiniyam provides for the admissibility of electronic records. So admissibility, how far courts will accept this electronic record, and what are all the conditions which need to be followed for admissibility, and the certificate of admissibility has been clearly explained under section 63, and the courts will use this particular section for admitting the evidence. Contravention and offense, as I explained, so these are all contraventions. Can you able to change the slide? So access, download, introduce virus into the system. All these things are contraventions. So this was a main important contravention, 43A, compensation for failure to protect data. So this section has been replaced by DPDP Act, right? So this particular section has been replaced by DPDP Act. Why? Because the government felt that data protection itself is a big regime, and that needs to be regulated by a particular different or a specific legislation. Because in the act which has been enacted, DPDP Act, Data Protection Board of India has been constituted. There is no provision which is in the IT Act which provides for a board for data protection and all. And several stakeholders involved in data protection, like data processor, has been explained, and data fiduciary has been explained. It is a comprehensive act which covers everything, like from penalty, from if you take about the stakeholders, if you take about the explanation to data protection, what are all the constitution of the committee, which means the data protection board. All these things have been mentioned, and it is a comprehensive legislation. And with a single section, we cannot able to manage all the data protection and breaches which are happening in the recent times, right? So that is the need for the new act. And 44, penalty for failure to furnish information, and 45, residuary penalties. Residuary in the sense, if anything is not covered in the particular contraventions, then this can be covered by 45. That is residuary. Yes, can change the next slide, Messi. So these are offenses: tampering with source code, whoever conceal, alter, or destroy computer source code and documents used for computer program, computer system, or computer network, which is required by law to be maintained, punished with imprisonment of 3 years and fine of 2 lakh rupees or both. So computer source code means listing of programs or computer command, design, and the layout and the program analysis of computer resource in any form. For example, GMeet. If you take this GMeet and alter the code of this GMeet, then that is also amounting to this offense, and you will be punished with imprisonment of 3 years and 2 lakh fine. Not you, just an offender will be punished with 3 years and 2 lakh fine. Yes, kindly change the slide. So section 66, computer related offenses, as I already told. Whatever the if for example the contravention which have been committed, like dishonestly or fraudulently does any act. So this dishonestly and fraudulently itself is a term that amounts to evil intention, right? So if these two terms has been added to that is amounting to evil intention. And if evil intention comes to that particular contravention, I said previously that it amounts to an offense. So if contravention wants to become an offense, it needs to be converted, be merged with evil intention, right? So this evil intention, if it is added to that particular contravention, it will be converted to an offense, and dishonestly defined, which is defined under section 24 and 25 IPC, and IPC also has been replaced now by Bharatiya Nyaya Sanhita. So you should need to always update with the law, because law is like living organism. It evolves over time. Okay, can you please able to change the next slide? So 66A2E, different types of offenses, computer related offenses have been explained, because 66 just generally explains what is a computer related offense. But 66A2E, one by one, actually specifically addresses certain types of computer related offenses. For example, 66A alone describes about punishment for sending offensive messages through communication device. As I already said, like Shreya Singhal was in India in that case, just promoting a hate speech against the government is an offense. So that can be easily fitted into this particular 66A. But in practice, I can able to see that policemen are always trying to file FIR on 66A for any type of offense which is happening online. So these are all being embedded into one particular section called 66A, but that is not the case. There are several specific type of offenses for which separate type of numbers have been given. Right? Yeah, I will send this study material. I will just give it to Joy. Right? Okay. So can you please able to change the slide? Yeah, next slide. Sending offensive messages through communication device. So I will send the comprehensive material for an entire semester. If you are studying law or if you are able to do study a course on this particular area, I will just able to provide a comprehensive material which I have, because I couldn't able to explain all the things which I have because time is very short. So I will give the material. Don't worry. So sending offensive messages through communication devices. So this thing, the 66A has been explained clearly in this: causing annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation, enmity, hatred, all these forms of offenses. If it is if it is happening, then that is amounting to offensive messages through communication device, and the punishment is 3 years and fine. So in this case, Shreya Singhal versus Union of India, which is a landmark case, right? In this particular section, Shreya Singhal versus Union of India, if you are not from a legal background, just to inform them that actually whenever a case law which is dealing with a particular section comes upon, we take note of that, and Supreme Court's decision will be binding upon all the stakeholders in the country. So that is the rule which is provided under the Constitution of India, right? So the binding nature of Supreme Court has been provided under Constitution of India. And then the article also was there. So article 142 provides for binding nature of Supreme Court. And all the decisions which have been made by Supreme Court will be binding. So if Supreme Court discusses on 66A as unconstitutional and it should be struck down, so in this case it has been happened. So section why? Because 19(1)A provides for freedom of speech and expression in not only in cyberspace but in general. Freedom of speech and expression to individuals and citizens. Right? So if the individual right is to be violated on the guise of protection of the government or maybe the sovereignty of the country, so this actually creates a discordance with what two things, right? One is the freedom of speech and expression, and another is the right to the government's right to cut off the things, like in the name of sovereignty, in the name of public health, morality, all these things which are mentioned in Article 19+2 as restrictions, right? The restrictions for freedom of speech and expression. Okay, so in this ground, it is proportionate nexus was established to attract reasonable restriction, and the government is not licensed, or maybe they are not, which means they couldn't be able to do. They should not do this particular thing, because the proportionate nexus need to be proved between freedom of speech and expression and the reasonable restriction need to be imposed upon the government. Right? So if the proportionate nexus is not achieved, then the particular provision will be held unconstitutional, and so this is what happened in this particular case. Government held to be violating the principles. Okay. So can you be able to go to the next slide? Yeah. Next slide. I will go. So like the 66C. So this is identity theft. Identity theft, you all know about this phishing and all, right? What is phishing? Sending some of mails, sending links through mails or maybe communication service. Just the offender will send a mail, the link, and if you touch the link, your personal information will be stolen by the particular individual, and with that personal information, that is called as identity theft. First, the modus operandi is committing an identity theft, and after that, with that identity, they will steal your money or maybe use it for a different purpose, or maybe it is up to them to do. But doing an identity theft itself is an offense, and making use of electronic signature, password, or any other unique identification feature amounts to identity theft, which means personal information which is stolen by an individual without your consent. And this, if it is done through link, then that is called as phishing. If it is done through phone call, then that is called as phishing. And if it is done through the messages, then that is called as smishing. So these are all different forms of phishing, and the punishment is generally 3 years and 1 lakh fine, right? So an example has been also given by me. A celebrity has approached the police alleging that someone has filed the income tax returns for a particular year in the name online without her knowledge. So this is amounting to identity theft, because income tax return can be filed only by the person who is an assessee. So without the consent of that particular person, how can someone file on behalf of them? So that is also amounting to personal identity theft, right? So next slide. 66D, cheating by personation. So there is a difference between identity theft and personation. Personation means, for example, a deepfake is also an example for personation. Recently, I have studied in on news article that some persons deepfake the video where it is shown that it is like an original video, and they have stolen money from the person who is trusting that individual. So that can be happening in the recent days, because deepfakes are that much influential. For example, they actually, I can able to do a deepfake of my photo, and I can able to make you listen to me for 1 hour as the same way I speak. Right? So that is the influence of deepfake in this recent era. So that is a really a concerning area where we need legislation, and not a legislation, but we need to address at least the issues. The government needs to take prompt actions. So actually the rules has been released. It will be coming soon. So this is personation. Cheating actually personation is, for example, if you want to explain like me, they will personate, which means another person. Like not only me, any other person. If you want to personate, you can able to. The personation, for example, if fake ID, if fake ID, that is the best example of personation. Fake ID is the best example of personation. Okay. So 3 years
Sorry
on.
to interrupt, sir.
Yeah.
Sir, could you please try to conclude the session as we are running out of time?
Yeah, sure. Sorry for taking much time. Actually, you given 15 minutes later to me. 7:15 only I started my lecture. So sorry for that. Sorry. I will conclude, right?
Okay.
Can you please able to move the slide? It's about to complete, right? It's about to complete. Yes.
Okay, sir.
I'm in the final leg of the completion. So 66E, violation of privacy. So these three are interconnected: privacy, personation.
Sir, your voice is breaking. Like your voice is not audible.
Sorry for the interruption. Actually, next slide. So this is a violation of privacy, and only one crime is left. So that is cyber terrorism. Terrorism is a larger form of offense. Only one particular section will be having, which means imprisonment for life. The life imprisonment under this particular act, the entire act. So ID Act, under this ID Act, only one particular section will have this imprisonment for life. So that is cyber terrorism. Cyber terrorism is intent to threat or unity of integrity of the nation or sovereignty of the India, or to strike terror upon the people. Mumbai terror attack, they used hacking methods to commit the cybercrime, and also the terrorism which is linked to the cybercrime. Okay, so this is one example for that. Can you please able to? Actually, it will be over. So this is a final form. One is 67, very important area, publishing obscene materials online. And 67 will punish persons who publish obscene material online. For first conviction, it is for 3 years and 5 lakh imprisonment and fine. And if it is for second conviction, 5 years and 10 lakh. So next slide. We will go a bit faster. So just 3 things you need to remember. I don't want to show you slides. 67 with obscene material. 67A, it is for pornographic content. Sexually explicit images online. When you spread or transmit sexually explicit images online, that will be penalized under 67A. And if it is a child pornographic content, even if it is child pornographic content, even watching is an offense. But for pornography, there is no such punishment for watching. Only for transmission and also the storage, they given the punishment for. But for child pornography, even for watching, it is amounting to an offense. So child pornography is completely banned in India and in most of the countries. Okay, so that's it. So this is all about the overview of ID Act. I have missed several areas where jurisdiction has been missed, because it is a transnational aspect where cyberspace is a transnational area, right? There is no borders. Jurisdiction is a very important area, and that is that I will, if I have a chance again, I will just explain in the another class. And also I missed to explain all the other aspects relating to this, which means the artificial intelligence, IoT, and other devices. How can it be regulated? So there is no regulation still no relating to the recent technologies of blockchain technology, the bitcoins, and even the High Court has given legal recognition to bitcoins as a property. So all these things, if I have a chance, I will definitely come and throw some light on it. And thank you for giving the opportunity, and thank you for your patient listening, all of you. Hope it is useful for you, and thank you for bearing with me for 1 hour. Thank you all.
Thank you so much, sir, for that insightful and thought-provoking session. For 5 minutes, can we just keep a Q&A session with your permission?
Oh, sure.
So, participants, do you have any
actually, they started asking. Actually, SMS bombing is legal. SMS bombing. Yeah, bombing is illegal. It's not legal. If bombing, like sending an excessive message to a particular person, right? So that is illegal. You cannot do.
Participants, if any other questions, you can ask sir directly. Please unmute yourself.
So the solution is you can mark it as a spam and block this number. That is the solution. Or you can, if it is offensive content, you can file a complaint with the police. So the cybercrime reporting portal number is 1930. If you are from a non-law background, kindly know about this. 1930. And you can also have you will file a complaint on cyber space portal, which is there, cyberportal.gov.in. If you search in online, it will be there. Any other questions? Still people share pornographic content. Yes, still it is there, but it is not legal. Because government issued blocking notification of pornographic sites under Section 69A of IT Act. But even though certain sites cannot be banned because of the VPN access which we have, and also the virtual private networks which we have, and also the other the social media platforms like Meta and Telegram, and also the Facebook, right? Sorry, Instagram and Facebook, all are Meta, right? So the Twitter and other things, the pornographic contents are still being widely circulated. So why? Because the stringent action was not taken against the intermediaries, and this recently enacted 2021 rules has been lacking in that particular aspect, as I can see, because pornography is not been they have banned that, but they have not given a mandatory opinion on this needs to be done or need to be removed by the intermediary in a prompt way. They just focused only on the hate speech and also the speeches which are against the government. So that is what the main aspect which they impose. But community guidelines are there. Nowadays they are removing the content. Mostly they are removing the content. Any other question?
I hope all questions are cleared. Thank you so much, sir.
I need to address. So India is the largest populated country in the world. As any question which is like why still it is prevalent, or how 100% accuracy is not achieved even after these laws have been imposed. To answer the question, in a country with 140 crore people where everyone is having, maybe most of them are having mobile phones, you cannot able to see where the penetration is happening, where these things are going wrong. And even in such a case, even we have the cybercrime reporting portal, the NCIAPC, sorry, Infrastructure Protection Center, and also the CERT, Computer Emergency Response Team, which are promptly receiving the complaints and taking action against the perpetrators. Even though we are having all this stringent forum and other areas where we can address the cyber crimes, we couldn't able to stop this because of the population, because of digital access, cheap internet, and even the intermediaries are not following the guidelines which have been imposed on them. So that is the reason why pornographic contents are widely spread across the sites. So still we will plug the gap. Anyways, in each and every area, India is trying to do best, but anyway, it is still A 25% lack is always there. Yes.
Thank you so much, sir. On behalf of Naksh Foundation and its national initiative project CyberShield, I extend my heartfelt gratitude to our guest speaker, Gokul Prasad sir, for sharing his valuable insights on the Information Technology Act 2000. Sir, your clear explanations and real-world examples have truly helped us understand how the IT Act serves as the backbone of India's digital governance and ensures accountability in cyberspace. A big thank you to all the participants for your active involvement and enthusiasm throughout the session. Special appreciation to the organizing team of Project CyberShield for their efforts in making this webinar a success. Before we conclude, a gentle reminder, please fill out the feedback form shared in the chat box. It is mandatory for receiving your e-certificates and will help you to stay updated about our upcoming awareness events. With that, we officially conclude today's session. Thank you once again, sir. And thank you to everyone who are present here. Wishing you all a safe, secure, and responsible digital journey ahead. Thank you so much.
Yeah. Thank you. Thank you for your wonderful thanks note.
Signing off.
Yeah, shall I read?
Yes, sir.